With it now. Again, I want to good morning to friends, and I welcome to this webinar series organized by ISM-INDIA. The focus of today's program is legal implication on procurement. Now, I did my first program on the same subject in 1999. I'm just trying to show you the book which I'm still carrying with me all the time. We did the legal implication of procurements. This was the first program I did in 1999, and then we followed this, I would say, around in 20-25 cities worldwide. Some of you may be thinking, I'm not a legal expert. Let me again admit it. I'm not a lawyer by profession. But being in the procurement, I always felt the need of knowing the legal side. Otherwise, when you're negotiating, when you're signing something, you are at the mercy of the legal people. You find yourself handicapped. So we always felt that the procurement people need to have a very good basic understanding of contract formation, how to form a contract, what could be the potential risk around, what could be the consequences when I make a contract around. So pre-contract, there are some risks around, mostly in the public sectors when you're doing the bidding exercise. In the private sector, most of the risks are after you sign the contract. So after you sign the contract, the post-contract stage, there could be potential risk around. How do I mitigate them? How do we overcome them? If I'm not aware of the risk around, I don't know the legal side, I will have a handicap. I can't do a good justice to my job. This is where I felt that we need to learn it. So this is how I did my first program in 1999. And in this program, I covered my own practical side. Then later I did some program along with the lawyers, and I feel this is for every procurement person need to know the legal side. So that's how I look at it. And as it is, when we talk of procurement, it's a cross-functional. You need to know the finance, you need to know the legal side, you need to know the commercial side. So I think more the knowledge, better it is. Well, friend, with this, let me go down to the next ones, the agenda for today. So agenda, what we have covered up, again, I'm trying to make it very practical. The way I have looked at it from my experience of 40 years, and when later on I did my program in contracting. First thing is to understand what forms a contract. I think it's a very basic necessity. How the contract is formed. Second is, how do I implement it? So when I implement a contract, what are the two parties are involved? What are the liabilities? What are the gains? So I need to spell it out very clearly in the contract implementations, the liabilities and requirements from both the parties. The next is securing a contract performance. So this is where I feel the procurement people need to be very good on this. How do we assure the performance? You made a contract, you got a wonderful deal, good price, but later on, the supplier is not willing to work. You ask for X requirements, the guy has not understood it, gives you a bad job. And then at the end of the day, you lead to legal disputes. How do we can avoid that? How can we improve the performance? Next comes, whether we like it or not, in the contracting world, there are all type of issues around. Some contracts will go very smoothly, no worries around. I've done contract up to $100 million single contracts. In Iraq program, I did one contract alone was touching 100 million. You have problems. Some of the things we can't foresee it. So when you really move through the contract, then you have problems. And then you say, guys, come on, this contract is becoming too frustrated. As you and me get frustrated, contract also gets frustrated. Then you're left up with no choice except to terminate. And then when you're doing termination, or there's a breach, you really need some remedies for that. Have you built those remedies into your contract? If not, then you are in trouble. The next comes the terms and conditions, T&C. I know most of us followed blindly the boilerplate given by our legal people. So legal people says, guys, this is the terms and conditions. It's just like a Bible, just follow it blindly. And if any questions come from the supplier, Many of the procurement people are not able to answer it. What is the liability clause? They walk down to the legal people for every small things around. So I feel the procurement people need to understand these terms and conditions which are built into the purchase orders, are built into the contracts. They need to understand each line. And the next comes the drafting of the contract. So when you're drafting a contract, how are you taking care of SLAs, the performance indicator? How are you taking care of applicable law? Particularly, which law is applicable? If the company is an MNCs, are they going to follow our law? Are they going to follow their own country law? Are they getting into arbitrations? Are they going, what approach they are going to follow to handle the disputes? So this is what I plan to cover in the next 1 hour. So with this, let me start to the next. So before I come to the contract formation, again, as a memory freshing the whole, most of you know it, the process starts from planning. The very first thing you get involved in the organization is, should I make it in-house, make or buy decisions? Should we go outside, subcontract, outsource? I mean, that's the role which is growing in a big way. Solicitation. We try to solicit the offer. It could be through RFPs, could be through RFQs, could be through ITBs. So you try to solicit the offers. And once you receive the proposals and you receive the offers, the next comes, who is the best? And then based on that evaluation process, you award a contract. Contract award. Then the contract administration or contract management, I would say, around. And lastly, once the job is done, you close it. You could say termination, you can say ending the contract. That's how it comes up around. So let me walk through. Actually, there are legal disputes in every step, but my major focus would be from the making of a contract till closure of a contract. Let's understand what is a contract. Now this term comes very oftenly with all of us. Sometimes we say agreement, sometimes we say MOU, sometimes we say contract. Are two things different? Is agreement a contract? Or is contract an agreement? I would put it this way. Anything which is legally enforceable, that is a contract. There are some components of a contract. It starts with an offer. In a very basic way, I've said, I will mow your lawn this weekend if you pay me this much. So there is an offer. So somebody is giving an offer to someone. There's an acceptance. Yes, you have got a deal. And then there's a consideration. So these are the three broad areas around of a contract. There are more elements, I'll touch on it. So keep in mind, a contract is formed if there's an offer. Second, if you're an acceptance is to be mirror image, no if and buts. And consideration. Consideration means how much you're going to pay me for that. So there has to be consideration for that. Now here comes very clearly around. You can see the two circles. Agreement is one. Legal obligation is this. And two places they are cutting each other. That's a contract. So agreement could be a standalone, but wherever the legal obligations comes in, it becomes a contract. So the summary becomes, all agreements are contract, but all contracts are not agreements. So contract is nothing but agreement plus enforceable before law. So the contract requires that the agreement should be enforceable, while agreements, I mean, they could be contract if they become enforceable. So this is how the summary comes in. So again, I have tried to put down agreement is equal to offer plus acceptance, while the contract is of agreement plus enforceability at law. If it is not enforceable, enforceable means there's a consideration, there's a legal capacity. I'll touch those points around. If it is enforceable, then it becomes a contract. So termination of a contract could have some liabilities, could have some issues around to be settled down. Agreement could be that you meet a friend, guys. Okay, we are meeting today in the evening there. Your friend accepts it. It's just an agreement. There's no consideration. You can't raise a dispute, oh guys, I have wasted so much money, you pay me so much. There's no contract. So contract becomes once it is enforceable by law. Let's start with the very first term, offer. Offer is nothing but invitation to make a contract. Those of you who are in procurement, you send invitation to the companies, to your recommended vendors. Hey guys, oh, we look for this. We need 40 computers. We need 100 chairs. You invite them to make a contract. You also do a bidding on eBay. This is also example of offer. You put a price tag in a store is also an offer. So you go to the department store, there's a price tag there. So that means somebody is giving an offer, guys, and then you accept it, you pay the money, the contract is formed now. Offer can go back and forth. Someplace we haggle the price. We negotiate the price. So offer could go back and forth, offer, counter offer, then offer. So it goes on, we call the battle of forms, until you have reached an offer which is 100% accepted as it is, including the terms and conditions. That's what we call that way. Next comes the counter offer. Counter offer means somebody has given you X price, you say, guys, I want to change. Somebody has given you payment term, you change it. You change some liability clause, again there's a counter offer. So counter is always counter till it becomes accepted by both. Till that remains is a counter offer. Now these offers, when we make it, they could be terminated. You give an offer to someone, guys, okay, my friend, this offer is valid for 3 days. If you don't come up after 3 days, I'm sorry, this offer is not there. It is lapsed. You could reject it. You could make a conditional offer. If you do this, I will do this. Or the guy who's making an offer has died. It could be death of an offeree and offerer. So the word is offerer, the guy who's offering it. Offering is the one who's other side, who's accepting it. You could revoke it also. So the offer could be terminated on these grounds around. Then this is again invitation to treat. Somebody gives a catalogs to you, here is the price. But when you go and buy it, the guy says, sorry, oh, this catalog is old. I can't sell you at this price. This is what we call as invitation to treat. You can invitation to treat in the catalog, and you can't take the catalog company to the court. Oh, your price was so much, and now you're asking me double the price. That's what we call invitation to treat. So offer, you know it, I don't want to repeat it, but invitation to treat is you're trying to invite, encourage people, come, buy from us. But still you could change it. You're trying to treat people around. So offer, once we talked about it, then come the acceptance parts. It's a good handshake, agreeing as it is without if and buts. So if you're going on online, you're clicking it on the button, you're trying to buy a software, you just say I accept, press the button, online contract is formed around. You're winning an eBay auctions, you're buying an item in the store, you're accepting it. So those are the store acceptance part in totality. Next comes the validity of acceptance. Well, there was an offer, there's an acceptance. How far the acceptance remains valid? So it is only valid till my offer is valid. So keep that in mind, they go together, it must be unconditional and it has to be communicated to the offerer. Now communication can be in writing. Communication can be also by conduct. Many of you are sending purchase orders. You expect the suppliers to sign it. Sometimes they don't sign it, but they start doing the job. So by conduct also it becomes an acceptance. Consideration. The third key element is consideration. The courts will only enforce a contract if both sides are getting something. I'm not saying getting less or more, but there has to be something. What each side gives the other is called the consideration. This is why you might have seen sometime we hire a consultant, but we put some price. even $1, 1 rupee, consideration has to be there. So at a zero price, you can't have a contract around. So contract means there has to be something, even just nominal amount, 1 rupee, or in the USA, $1, contract has to be there around. Now comes, consider there's no contract if one party promised to do something and the other party is not promising in return. So there's no consideration. And consideration cannot be from one side. This is how I will try to differentiate consideration with a gift. So in the case of gift, you say somebody, guys, on your birthday, I'll give you this. There's a consideration. But that consideration is a one-side promise. You can't drag me to the court that you told me last year, I'm going to give you a gift. It's all one-sided promise. So that is not supported by a consideration. So that's what we call as a consideration. So keep in mind, consideration and gifts are two different things around. Consideration means both parties are getting something, either the benefit and detriments, something has to be there both sides. It is not only one guy is getting it. Then the battle of form, which I told you in the beginning, very high values contract, it goes on very often. Supplier and buyers, they go back and forth. I don't agree the payment terms. I don't agree the liability clause. I agree with this. I can't pay you this. If prices goes up, back and forth. That's what we call the battle of forms. So the battle of forms ends when offer and acceptance is accepted in a total form. Components of a contract. Now I think we have already understood what forms a contract legally is, or these are the ones, bullet I put around. Offer and acceptance is the very first thing. Next come intention to create a legal relationship. You have said offer, you have accepted it, but are you serious to make it a legal relationship? Lawful consideration, as I told you, there has to be consideration. And the word is lawful. It is not the consideration. It is the lawful consideration. Capacities of the parties. No minor can sign a contract. Or if a person is of an unsound mind, also cannot sign a contract. If people's also persons disqualified by law to which they are subject, some people might be disqualified, they are already bankrupt, something, they cannot sign this. Then there has to be free consent. The guy should not be under pressure. No coercion, undue influence around. No fraud around. Sometimes you misrepresent the data around. So somebody is not very knowledgeable and you try to give misrepresentation, that is what we call the fraud. Or there's a mistake. Under those conditions, again, contract becomes void. So contract is not valid. So keep in word the two words, void and valid. Is the contract valid? If any one of these happens around fraud, mistake, coercion, you could put them as a void. Now, in your day-to-day life, you agree to a contract. You sign a credit card agreement. The contract is formed. You signed an agreement related to a job. The contract is formed. So I've just tried to put something you're buying from a store. The contract is formed. So you sign on a daily basis something which is a contract. Now the contracts, as I said in the beginning, it could be void. That was never legally valid. Voidable. That means you could make it, so it can have legal effect, but you could make it a void. You could annul it. And the last is valid. So the valid contract means which is legally enforceable. If dispute happens, you could seek damages, you could go to the courts, you could go for arbitration or whatever methodology. You can look for some relief around. For void, you can't look for a relief. So valid contract, you can look for a relief around. Now the contents of the contracts could be expressed. So when we make a contract, there are terms and conditions, you all know it. Some terms are express terms. Express means you express them in writing. Implied mean is understood. You go to a restaurant, you're placing an order, there's an offer, there's an acceptance, you're paying money, the contract is there. But then there's the implied condition that the food which is being served is hygienic, fit for use, fit for eating. So there are implied terms around. You're not writing in a contract that, guys, okay, I'm placing an order for the tea, but this should be so and so. It's understood. So that's what we call the implied terms. Conditions. So there are terms, conditions, warranties. Some things are warranties. You buy a chair, you expect that this is going to last. You're not writing everything around. Although you'll put down your quality requirements, but then you're looking for a warranty for 5 years. This guy will work for 2 years or 5 years, depending on the product. So there are warranties around. And there are some terms which could be exclusion terms, which you may like to remove it. Particularly this happened in the real estate business. Sometimes some contracts are excluded, which gives benefit to the builder, but not to the person who's taking it. So this can be taken out. So implied and express terms. So express mean you're putting down in writing or verbal. Verbal is also treated as express terms. You may not have put in writing, but you explained it. But the only problem come in a verbal is your word versus my word. Who is going to prove that you said like this? Or what was the meaning of your words around? That could have problems around. So it is normally advisable to have a written express contracts around. Implieds are there. So as I said to you, one example I gave you. So there are some things which are implied. Let me give example of the implieds around. You buy a boat. The first day you are going for sailing and the boat sinks. Now the boat is sank and then naturally you're going to complain to the seller, guys, I bought the boat. Then he tells the contract did not promise the boat would float. But this is implied. Obviously you are not going to write in the contract the boat should float. Naturally you bought a boat, it is supposed to float. But the smart guy is saying, guys, I did not promise, the contract did not promise the boat will float. So one of the terms implied into a contract of the sale is the goods of satisfactory quality are fit for the purpose. Same thing can happen with the food items. So keep in mind there are implied terms around. Then come the conditions. These are the fundamental terms. If the party does not carry out those conditions, we call them C's, you can claim for damages. And also to treat the contract as terminated. If things don't follow, it could be payment condition, payment term, whatever you talk about. So those are the ones which has to be must. Warranties. The warranties are of lesser importance. Somebody has given you, made a house for you and some civil works for you, has given you warranty that this will work for 5 years. If after 3 years or after 1 year, you can't terminate the contract based on warranty, you could seek the damages. In the case of conditions, the terms and conditions, you could seek for what you call as termination. That's a major breach. Material breach I would call around. Warranty is not a material breach around that way. Exclusion clause, I told you that there are some clauses. You can always look for some benefits for that. Ending the contract. A contract can be set aside, cancelled, if later it appears there was a wrong misrepresentation. There's a duress. Somebody is putting a knife on your head. Sign it. There's an undue influence around. There's a pressure, either politically or something. There's a mistake. Under those conditions, contract can be set aside. Contract can be discharged where the contract is valid, but comes to an end. Because it has been carried out, the parties agree to end it, and there is a serious breach of contracts around. Terminations. Now the terminations can happen under 4 areas around. One is performance. You gave me a job, I did it to your satisfactions. If I've done the job to your satisfactions, performance is done fully. After the job, contract comes to termination. I mean, contract comes to a closure. So termination, don't think that we are trying to take as a negative. Termination means come to a closure here. Then there's an express agreement. Two parties sit together, guys. We are having difficulty. The funding is not coming. Let's sign a contract. And we express the agreement that this contract is terminated for some reasons. And whatever is the liability for each, everybody cares. The third is a breach. You define the expectations. You define the limit. You define the date when it has to be done. But if it is not done as per that, then there's a breach. And for every breach, there's a remedy, which I'll touch in the next slide around. And then there's a doctrine of frustration. As you and me get frustrated in our life, we say, guys, bye-bye. I don't want to work in this company. I'm frustrated. Same way with the contract also, we get frustrated. Things are not moving. Then that's the doctrine of frustration. We try to terminate. Next come the remedies for breach. Now the remedies could be damages. You seek damages, claim for damages. Guys, you were supposed to deliver me by this date. It has not happened. I've delayed by 1 month. I've lost my business because of this. My reputation has gone down. So those damages you could seek claim for it. Or you have made a specific performance requirements and that is not done as per that, you can again claim. You can go to the court and ask them to seek for the performance. Injunctions. Or last is suspension of performance. Terms and conditions, broadly I'll just walk through it. I know it's a big list. And looking at the time frame, I'll touch the key issues around. First thing is the legal status. Status of both the companies. Source of instructions. Who's going to give instructions around? If there are supplier and buyer, supplier has to know who's going to give me the instructions. Who is the one? Contractor's responsibility for employees. You give a contract, nowadays we're doing a lot of outsourcing. I'm in the shoe business. I give a contract to someone and that guy is hiring so many employees. Are they paying the right salary to them? Are they giving the right working condition to them? If something goes wrong there, my image also gets spoiled. Assignment. That means you give a contract to someone and the guy has coolly gone and given the whole contract to someone. That means that guy becomes like an agent. I give a contract to someone and that guy coolly goes and gives to someone. That's called assignment. Are you guys allowing assignments? Mostly companies put down, if there is to be assignments or subcontracting, it has to be at the consent of the buyer. So the buyer has to approve it. Official not to benefit. Again, this is to avoid the corruption. No officials can get a benefit. Indemnify. I don't want third-party liabilities. I've given a work to someone to develop my software and the guy has taken somewhere some source code which is not open. Naturally, when I use the software and the company from where this guy has taken, that can sue me, the guy, you're using my software. It's not available for use. So you want to be indemnified from third-party liabilities around. Insurance, liabilities of third parties, all those things are there. Title to equipment. Now supplier is giving you equipments. Supplier is giving you software, like in the case of Microsoft. Are you getting title to that? Copyrights, patents, trademarks. Use of name and emblem. People are very particular around that, okay, we are giving a contract to you, but then you will not be using my emblem everywhere to tell the whole world. So you have to get my approval before you display anywhere that I'm working with someone and trying to display the name of mine. Confidential nature of document. Some of the designs are very confidential. You are doing manufacturing for them. If you pass on the same design to the company, to the mine, that's what we call the confidential nature of document. Force majeure is again a French word, act of God. That means something which is uncontrollable. You're given a contract to someone, war happens, riots happen, flood happens. So under the force majeure, you could not terminate the contract. Terminations could also be at a will. So both parties agrees and they could terminate. Although there will be some, you can say some damages will have to be paid for that. Settlement of disputes. How do we settle the dispute? Do we go through arbitrations? Do we go to the courts? Do we negotiate? Do we do the mediations? What payment terms are going to be there? Is it going to be 30 days after the deliveries? So the payment terms are also equally important around. Export license. Who takes care of export license? Particularly when you're buying goods from abroad. I'll touch this little bit under the Incoterms. So there I can touch a little more on this. Risk of loss. My goods are coming on the ship from Hong Kong. On the way the ship is sunk. Who is bearing the risk of the loss? Some theft happens at the port, at the customs. Who's bearing the risk around? You need to cover those liabilities as well in the contract. Fitness of goods. I spelled it out if this goods has to be used in these conditions. Are they fit to be used? And the grants of license, limitation, restriction, escrows, all those things are there around. But the key clauses which are there is payment terms, indemnity clause, and the liability clauses. I have done a lot of discussion on the liability sometime. So we used to have a contract. We'll say, guys, if this doesn't happen, then you are liable for 10 times the amount of the contract. Suppliers will say, guys, this is too much. So we used to do a lot of negotiations on that. So liability clause is very, very crucial now. Confidentiality, exclusion clauses, dispute resolutions is again very important. How do we handle the dispute? Particularly those who are not working within the countries, who are importing goods from abroad, who are doing a lot of outsourcing, I think the dispute resolution becomes very critical. Governing law, which law is applicable to us, and transfer of ownership and risk. Next comes the writing of the contract. So we have understood what forms a contract, what are the terms and conditions of a contract. Now the broad framework of the contract would be, obviously use the core contract boilerplate. We use the word boilerplate. The boilerplate is the standard terms and conditions given by the legal unit. Statement of work. Here I'm using more for the services, let's say. What are the services you want to be provided? The manner of service provision, how and what is covered. And then we had also to talk about the performance specs. How do we spell it out that this quality of job which is done by the supplier is up the mark? How do we measure it? So there's a measurement part has to be there. How do we measure the methodology? That methodology has to be there around. And then method of payment, how payment has to be done and when payment has to be done. Here I want to again tell the when, which I had a lot of discussion sometime. People say 30 days after receipt of goods. Then they're using the shipping term as CIF, CPT, FOB, X works. So when I use those shipping terms, the liabilities has been already passed on to you under those terms at X works place, at a SIF place, CPT place, and then you are saying 30 days after receipt of goods, supplier has got no liability to give you up to the delivery point. Delivery, you are taking care of it. So that makes a big difference around. So some people write 30 days after receipt of goods, then your shipping term should be also delivered terms like DDP. So those type of terms has to be used around. Special provision. Here also I want to touch a little bit on offer and acceptance. Some suppliers, I have done quite a big discussion on with my previous team in the offer comes from a supplier. Because you asked for the bid, supplier has given you offer. So in the purchase order, you write or reference your quotation, whatever this around. You put down the reference of the supplier as an offer, and by making a PO, you are making an acceptance. So keep in mind, the moment you make a PO and giving a reference to the offer by the supplier, so again go with the real basic definition, offer from a supplier, acceptance by you, the contract is formed. Then the next question comes, whose terms and conditions are binding? Supplier has given you the offer with their terms and conditions, sales conditions, given at the back of the sales order, which you may not have read it even. So if tomorrow there's a dispute, they could be the binding one. So this is where I normally tell the people around, guys, offer has to be from you. You are the buyer. You get the quotation from the supplier, but convert in such a way it looks like an offer is going from you, and then they accept it. Contract implementations. Now here comes, what should supplier do, what should purchaser do? So there are rights and liabilities on both sides around. Obviously, supplier has to deliver the goods based on when, where, and how as defined in the contract. Hand over all the required documents. Transfer the property of the goods. Deliver the goods as required by this one. And deliver the goods which are free from any right or claim of a third party. The guy should not steal the goods and give it to you. They say, guys, okay, I've done my job. So that means there is again a claim from a third party possibility. Same thing happened with purchaser. So purchaser also has to inspect the goods, whether they define to the conformity, accept the delivery. You can't say, guys, oh, I'm not going to accept it now. Pay the price of the goods. You also have some responsibility. As a part of implementation, the contract should state when the risk of loss or damage is passing from supplier to the purchaser. To a lot extent, this is covered through the Incoterms, shipping term. So those of you who are very well knowledgeable about Incoterms, they very well know when the risk of loss or damage is passed on from the supplier to the purchaser. So even if I don't spell it out, this is very clearly understood. The problem happens when you're buying locally. International thing, we are using Incoterms. When you're buying locally, you are not using Incoterms, many of you. While the Incoterms can be used now both internationally and locally. So when the domestic procurement you're doing around, you're not mentioning all this and you're not clarifying. I'm the supplier based in Mumbai, supplying to a company in, let's say, in Gurgaon or Chennai. On the way, if something happens, so we have to define when the risk of loss or damage is passed on. The contract should contain provision for condition for termination of the contract. You have to spell it out. Remedies for the breach of contract. Force majeure. Force majeure also, either they are defined as per the act, but if you want to qualify, you can come forward. Particularly for those cases when you go for arbitration. Preservation of goods. How are goods going to be preserved? Particularly the medical item, the food item. So you need to spell that. Now the breach of the contract I have explained earlier. So let me say again few points around. Not paying in full or on time, failure to deliver the goods is also a breach. You're giving inferior goods is also a breach of contract. Not providing a bond when required, particularly for the public sectors, again is a breach of the contract. Being late with excuses, all are those part of the breach around. So here it gives you some of the examples where the breach could be defined. Now the type of remedies. Now obviously there's a breach. So first you define that the breach. Now you're looking for legal remedies for that. And legal remedies mean you're looking for money damages. Now these money damages could be compensatory. You compensate me for this. Consequential damages. This word is very important around. I was supposed to get these goods on 15th of March and you gave me after 1 month. I don't need those goods now. I've lost the market. My, my reputation is lost. So I could make it consequential damages for that. Punitive damages around. You can also punish them, guys, because of this. Nominal damages, small amounts around. Liquidated damages. So liquidated damages is very commonly used. I'm sure all of you are using it. This is only when there's delay in delivery. But you have to define. Time is the essence of the contract. If time is not the essence of the contract, you can't say, guys, you delayed me 2 days, I'm going to charge you liquid damages around. So you have to make it very clear, guys, every time, every minute counts for me. And this is my cutoff date. If you delay it, I'm going to charge you liquid damages. You need to define it, liquidate it. And mitigation of damage. How do you mitigate the damages around? So that also could become part of it. Now behind the contract, the law which is applicable, Indian Contract Act. Many people get surprised. Indian Contract Act dates back to 1872 when we were not even independent. So Indian law is largely based on the English common law because of the long period of British colonial influence. We follow the, basically is based on the English common law. So this is the one which contracts our contract law around. It governs entering into a contract, execution of the contract, and the breach of the contracts are all governed through this act of Indian Contract Act of 1872. I know it has gone through many modifications, but still it's called the Act of 1872. Writing the contract. So when you're writing the contract, I think I've already covered, maybe it's a duplication in this case. So basic core contract boilerplates, statement of work, performance specs, methods of payment, special provisions. Special provisions could be something extra. You have, I have used quite a lot of special provisions. I use the contract boilerplate from the given by my legal people. Then I negotiate something. So those provisions overrule the basic core contract. So I used to put down, okay guys, as agreed, payment term will be this. As agreed, this will be this. Liability clause in the core contract rate was 10 times. We negotiate, come down to 5 times. So I make a special provision there. So this is how we can work. Then next come particularly for services. When you're buying services, IT services, you're contracting with Airtel, let's say, for getting, and you've got 10,000 people working with you, you're trying to get broadband connections. You can imagine if broadband connection is out every day 1 hour, and you've got 10,000 people, 10,000 multiplied by 1 hour, so many hours you're losing every day. Because the work comes to a halt when there's no internet connection. You want to define the service level. What type of quality of level service you're giving to me? People define it. So that's what we come under the service level. The next thing I want to touch about is Incoterms. Something close to my heart. I know we had done earlier one. My colleague Ravichandran did this webinar. So this Incoterm stands for, IN stands for International Commerce Term. This is universally recognized, developed by ICC, International Chambers of Commerce in Geneva. And this can be used both for international and domestic transaction. There's a big confusion. They think, oh, the word is international. It used to be up to 2000, up to 2009. By the time this new has come on 2010, and this was applicable from 2011, it can be used for domestic transaction also. So by putting this domestic transaction and international, you are able to pass on, you are able to define the liability clause, you are able to define when the damages passes on to someone, the risk is passed on to when, and this is accepted by the governments, legal authorities, and business. Just giving you broad, looking at the time, so Incoterms 2010, you can see the term which start ending beginning with D. Delivered terms, we call them. Delivered at terminal, DAT, delivered at place, delivered duty paid. These are the one delivered term. So supplier responsibility ends when they're delivered at destination. While in the case of C terms, supplier passes on the responsibility to the moment anything is done around. So you have to keep in mind your payment terms, your liabilities, your responsibilities. You have to take care of it. Now the types of contracts. Here also let me touch what type of contracts are there around. One is the fixed price term contract, lump sum, which is the best. In your budget, you're able to define it. But the word is so volatile, very difficult to put fixed price, particularly for the complex contracts around. I remember a contract when we had a duration of 3 years. We were laying down the transmission towers for 3,000 kilometers. Steel is involved, copper is involved. Now for 3 years, you and me know very well, commodity prices are going up and down. No supplier is going to buy the material for the next 3 years now. So they will try that the prices should be linked up with those prices fluctuations. We used to build into the contract, if this is the formulas, and in this formulas, if this item goes up and down, the rate will change. And we used to link the prices with international metal exchange around, like London Metal of LMEs for copper. Similarly for steel, you try to link up with international prices. And we take a base price. If the price after 1 year or 6 years goes up and down, according to that, the payments will change. Next comes the cost reimbursement. This one is a little bit loose, but there's no choice sometime. You're doing a research work. You're giving a contract to, let's say, research institutions or to a college. Obviously, then you're going to reimburse the cost. Sometimes it's very difficult to define, is it going to take 6 months? Is it going to take 8 months? In those situations, you try to pay them back on a reimbursable basis. You say, guys, do the job. You put the broad parameters. So within those broad parameters, you say, guys, okay, this cost will be reimbursed. But you have to do a lot of overseeing. The next type is unit price contract. We call them a T&C contract. T&M material. Time and material contract. So time and material means, particularly when we hire the consultants, we have a fixed rates and we pay them based on the time they've used with us. The consulting fee is there depending on the time you multiply. Plus the material contract. So if anything they have bought as a part of the project, we reimburse the cost around. So those are unit price contracts around. Now I have put down some poll questions. So before I open the poll, let me also read out those questions for you. There are 3 things around. You order a book of Amazon from Amazon.com, your credit card is charged, but no book ever shows up. So in the poll question, before I open up the poll part, was there a legally enforceable contract? Think it over. Yes and no. Second, you're sitting in a restaurant, you order a meal, you imply a promise to pay for the food. And obviously, you have said, okay, the restaurant serves you on the basis of, is this a contract? And the third is, you have promised to your spouse, I'll get you iPhone on the next birthday. However, she or he gave you his or her old, broken, basic cell phone. Was this enforceable contract? So while guys, I'm opening this poll, questions, I look forward to your yes and no for all 3 questions. Okay, first 2 questions. Okay, the poll is still in progress. I think before I go to the second questions, so I could see most of you have voted. I would put it this way, and the yes is 83%. So 83% people feel this is a contract when you buy a book from Amazon.com. 17% still people feel there's no contract. Okay, with this I want to move to the second questions. So here is a question about your going to a restaurant. Okay, let's listen to this and then okay friends, here I find out of 80% who have voted, 53% say yes and 47% says no. So there seems to be division. So some people still feel there's no contract. Okay, good. Anyway, I'll leave this for discussions and let's move to the next then. So this ends it, and I want to thank you again for your patient